Now let's get some more insight on this development. Join us virtually is a legal practitioner, Qudus Alalafia. He's joining us via Zoom from his home in Abuja. We're actually having to speak with Barrister Alalafia via phone. Barrister, good evening to you and thank you so much for joining us. As you can imagine, this is a conversation that has captured the imagination of the country for the past 2 weeks. But legally speaking, what is your expert analysis of the rules here? It does appear that Senator Natasha has broken a record because under the current democratic dispensation, no senator has ever been suspended for 6 months. What do you make of the nature of the suspension and the legality of it? Do we have Barrister Alalafia on the phone?
Yes, thank you very much. It's my pleasure to be on this program this evening. Thank you so much. Let's go straight to the question. The first one is the nature of the suspension, then the second one is the legality. If we look at the nature of suspension, or let me say the legal nature of suspension, of course, by the enabling enactments, as well as the standing orders of the National Assembly, whether Senate or House of Representatives. Of course, a member of the House or a member of the Senate can be suspended legitimately, validly, by either the Senate or the House of Representatives. However, such suspension must be one that must be done within the ambit of the law. It must be the one that whether the standing orders of the Senate in this regard, or even the legislative houses, powers and privileges act. It must be one that the law allows. Now, obviously, Senator Natasha is not the only federal lawmaker that has been suspended, whether legally or illegally in time past. But of course, our courts have had cause to come to the rescue. Of course, that brought to my mind the case of Dino Melaye versus Honorable Speaker, House of Representatives, 2010, a matter situation that had to go to the Federal High Court in Abuja, and Honorable Justice Bello, in suit number FHC-CS 46-2010, had to declare that suspension as illegal, null and void, on the ground that the suspension was not made in line with the enabling laws, with the enabling standing orders of court, of the House. Now, coming into the issue of Senator Natasha, the truth is that takes me to the legality. The mere fact that it is the the Senate President that sat and even announced the suspension makes the entire process illegal, makes the entire process unconstitutional, unlawful, null and void from heaven to hell. Why? Nemo judex in causa sua. You cannot be a judge in your own cause. Ordinarily, I was expecting. Can you hear me, please?
Yes, I can hear you, Barrister. Please go ahead.
Thank you very much. Ordinarily, I was expecting that in this regard, the Senate President will excuse himself, recuse, the way we say it in law, recuse himself and allow the Deputy Senate President to preside over. It is even an aberration that the Senate President was making a kind of response, a reply to the petition which Senator Natasha has submitted for consideration before the Ethics Committee of the Senate, while he was even sitting as the President of the Senate. You are the judge. You are also the defendant in the same complaint. Our law does not allow it.
Right. And
that is
Barrister,
why John Locke said it is too great a temptation
right,
how to grasp at power.
Right.
To give to the same person who has the power to make law, to also have the power to enforce it, is wrong.
Right.
Now, let me just end it like this. Let me conclude like this. Sorry. That the ethics committee as well said that they could not consider the petition submitted by Senator Natasha because it was not duly signed. Now, that is procedural, which can still be amended. So that means you are using the procedure to now conclude on the genuity, the truthfulness or falsehood of that complaint. Then the next thing that follows is that you gave her suspension.
Right.
Of course, from heaven to earth, like I said, that suspension is null and void. Thank you very much.
Okay, Barrister, let's double down on the nature of the suspension, or at least the content of the prayers contained in the suspension as submitted by the Ethics Committee. They talk about 6 months, which on record I think is the longest punitive measure that the Senate, especially under the current democratic dispensation, has meted out on a fellow senator. But also they talk about stripping her of her security aid, having no access whatsoever to her office or even the premises of the National Assembly, no salaries or allowances for the senator, but also for her aides, and she cannot parade herself as a senator from Kogi Central. Talk to me about how that in itself is, whether in accordance or in violation of the Constitution of the Federal Republic of Nigeria. Does the Senate have the power to do that?
Okay, thank you very much. You know, like I said when I was starting my submission, I said yes, the Senate or the House of Representatives, by the legislative houses, powers and privileges act, as well as their standing orders, they have the power to suspend. That is it. However, in view of the pronouncement from the court, particularly if you look at Ali Ondume versus Senate, you look at the case of Dino Melaye versus Speaker House of Representatives, you will see that the court has constantly maintained in interpreting their law, the law regulating the proceedings at the National Assembly, that you cannot suspend a member beyond 14 days. The law may have been amended, but that is the extant position of our court, which means that invariably what they are saying is that you cannot, by way of your own volition, decide to deny the representative or the representation of a particular district or constituency their legal representation in the House. If you look at various ones that we've had, particularly from the House of Representatives, we have issues whereby honorable members were suspended for 9 months, some for 6 months, some for even almost a year. And the court said, no, you cannot do that, because you cannot, because of whatever that has happened at the floor of your house, deny the good people of a particular constituency or district their legal representation. So what the Senate has done is to deny the Kogi Central Senatorial District their representation for 6 months. And we are even saying that the proceedings which brought about that sanction is invalid, is null and void. It is more or less like coming together to just call Senator Natasha a dog so that they can deal with her.
Right.
That is the way it is. So the legal implication is that they have denied the Kogi Senatorial District, Kogi Central Senatorial, they denied them representation for 6 months. And it is my humble belief that Senator Natasha has a good of action in court.
Right. And
just
of
like
course,
others in time past.
yeah, and of course, you've mentioned several of these cases. Dino Melaye v. The House of Representatives, Senator Ali Ndume versus the Nigerian Senate, Senator Oviyo Agege and the Nigerian Senate. Some of the most recent cases where the courts have been very clear about excessive punitive measures. And you did mention that 14-day period, which the court says is a fair punitive measure in terms of suspension. Well, as is typical of so many of these cases in Nigeria, the courts will be the next destination, and I suppose that is where the drama will go to next. Barrister Qudus Alalafia, thank you so much for providing us with some insight on this development. Appreciate you for joining us on the news.
Thank you very much. It's my pleasure.